the standard, no changes to that. But the other thing too is there's clarification as to telephone conferences and new requirements. Main thing is that boards clearly have always been able to meet by telephone conference. So long as you can be in different locations, you can be all around the world. So long as you can hear each other and discuss, deliberate, and decide issues, so long as all the directors can hear each other on the telephone conference, it may be done. I have one board in the Bay Area. It's kind of fun because they have laptop computers for 2 of their directors, and they set up on Skype. And 2 of our directors always appear on laptop. It's kind of a comedy thing because they're sitting there and you just see their heads. And they sit through the whole meeting. It's just kind of fun. So you can do it by that, you can do it by video, you can do it by telephone conference. You make the choice. When you do that, you still have to comply with the Open Meeting Act, right? There's no changes there. You still have to do a notice for a board meeting, a regular board meeting. You're going to give 4 days notice. You're going to post an agenda. You're going to set a physical location where members may attend, unless you're meeting in executive session. So you still have to do a physical location where members can go and hear the telephone conference. The other thing, this is my favorite, one board member must be physically present at that location. So if you have a 5-member board, one of your directors must go and sit there at the table, and I would generally suggest that they chair the meeting because they're physically present in the meeting, and that way there is a human that's sitting there and people can interact with. The emphasis, the cause behind that is so that basically when the open forum occurs, there's some director that's sitting there and is able to chair the meeting. And then everybody has to be able to hear each other, right? We get back to that again. When open forum happens, the members need to be able to hear the board, and the board needs to be able to hear the members. This is another big change. And if you've ever been in litigation, you're going to find this to be a very difficult thing. Executive sessions now require 2 days' notice, right? The theory behind here is you invite members to a party that they can't attend. Hey, guess what? The board's meeting 2 days from now. We're going to be discussing this, this, and this. By the way, there will be an agenda posted for this, right? So you have to do 2 days' notice. You have to do an agenda of what's being discussed in executive session. Members, of course, can consent, but no one can attend except for the board staff. It does not change the number of who can attend executive session. Your attorneys can be present, your management can be present, but the members you can exclude from this meeting, or just invite those that are being affected by it. The other thing too is there's a new change to the member inspection rights. They're entitled to inspect the agenda for your executive session. I hate to speculate as to why the legislature was so key on having these agendas, but this has occurred. And one thing you have to remember is your agenda should be very sparse for an executive session meeting. Do not include members' names, addresses, phone numbers, social security numbers, or any other identifying information with regard to member discipline, right? If you're calling a member to a hearing for member discipline, I think it would be very bad form, to put it mildly, to include the member's name on the agenda. I think it would be bad form to include, when you're talking about collection of assessments or decisions to foreclose, to include the member's name on the agenda. Generally speaking, you would probably be safe just to include one of the 6 categories of executive session on your agenda, whichever one you're going to be addressing, and leave it at that. My assumption is at some point in time there's going to be some clarification in the law on this issue. Probably the next few years we'll find out if there needs to be something more, if there's ever been a challenge to it. And then lastly, we're going to hit on some other points. There's other legislation that's out there. It's not just the Open Meeting Act. This is probably the biggest impact on boards is to change the Open Meeting Act. But there was also a bill this year that regulates rental restrictions in homeowners associations. This bill basically, just so you know, if you already have a rental restriction, meaning a cap or a percentage on the number of rentals that are permitted, this law has no effect on that recorded rental restriction that was recorded on or before January 1st, 2012. So if you have an existing rental restriction that was recorded before January 1st, 2012, it has no effect on that whatsoever. But just be aware that there are laws that now regulate into the future on rental restrictions. There's also bills on the electric vehicle stations that are placed in the association's common area. For example, if you're in a townhome or a condo where an owner does not have a particular location where they could install their electric vehicle charging station, there's very particular rules, but they may be permitted to install those in the common area and be marked as their exclusive use. What I would caution you about whenever you get one of these requests, talk to your attorney. The key about it is there are very specific requirements, right? The owner is going to be running a very large amount of power out into the common area through the common area. And there's a great deal of risk involved with that. We've heard about fires in electric vehicles. We need to be mindful that it needs to be done right. There's specific insurance requirements as well, and then there's maintenance issues for who on earth is going to maintain this charging station for the next 20 to 30 years. And then finally, there's some changes on document disclosure. I know that your management company is up to speed on that, but it basically requires the association to provide an estimate of costs before you turn over the escrow transfer package, where you say, here are the CC&Rs, here's this. We have to give them an estimate of what those costs will be in advance. So with that, I'm going to turn this over to Jennifer Jacobson, my partner, discussion on architectural review.
And we'll take questions at the end about the new legislation. That'll probably be the main questions that you have, but I get to talk about architectural review. How many people here have been involved in an architectural dispute with a homeowner in your association? Everybody here should have their hand up. Come on. You guys are all good at architectural review. Well, we want to talk a little bit about risk management today, and one thing that's really important is architectural review. This is probably one of the most important functions that you have as a board. You are charged with, as fiduciaries, with maintaining and enhancing the property values in your association, right? And the main element that's going to take care of that is the look of your community. And architectural modifications can drastically change the look of your community. If somebody doesn't do something that's in conformity with the remaining homes in your community, that could really degrade your property values, right? That could be something, if every house in your community is a neutral color palette and somebody comes in and paints their house a garish pink or purple, that might not be fitting within your community. So the application process is important. It comes with the power for your architectural review comes from your governing documents. The committee must decide in conformity with your governing documents. Your CC&Rs will typically appoint this committee, and then you'll have design review guidelines, architectural review guidelines that they implement. And the committee must decide whether to approve or deny an application in good faith and pursuant to the requirements or improvements and alterations set forth in the governing documents. How many folks here sit as the board as your architectural review committee? Some? How many have a separate architectural review committee? Some have separate architectural review committees. So the idea is if you have a separate architectural review committee, they must put in writing if they deny a project, because the homeowner has the right to appeal that decision to the full board. Okay, but if the board is sitting as the architectural review committee, the board is the final stop, and the homeowner must litigate in order to challenge that decision. So the best way to learn about these things is to learn what other boards have done wrong and what other boards have done right. So Dolan King is an interesting case about what a board did right. It's one of the seminal cases in this area of law. How many people here have been to Rancho Santa Fe, Southern California? Yes? Very beautiful community, right? Beautiful community. When you drive through, my understanding, I have not been, but my understanding is you drive through and you get a feeling that you're in France, and then you get a feeling that you're in Tuscany, and then you get a feeling that you're in the Mediterranean, because each region in this community has a different architectural feel, a very distinct architectural feel. This is the oldest community in California that has CC&Rs. It is, they do not have an architectural review committee, they have an art jury. This art jury decides what fits within each of these pastoral regions within this community. So Mrs. Dolan King comes along, and she wants to change out the fenestration, which is the window openings and door openings in her home. She also wants to add a fortress-like fence system to her home, a wrought iron fence system that nobody else in her region has. And she comes to the art jury with her experts, loaded up with her experts and her lawyers, and she says, approve this. And what does the art jury say? They say no. This doesn't fit within this community in spite of what your experts say. We don't like it. We don't like it. And we get to decide what we like. We don't like it. So what does she do? Just like all good Americans, she sues, right? So she comes along and sues the association and says, you know, they're applying subjective factors. Objectively, my application fits within everything in the CC&Rs and in the design guidelines. So they really don't have the discretion to deny this. And the court here said, you know what, the art jury does get to decide. They get to decide because they've been given the discretion under the covenants to say what fits and what doesn't fit. And they can apply not just those objective criteria, but also the subjective criteria of what they find to be fitting within this community. So it is proper, and we are not going to interfere